The Pinarayi Vijayan government in Kerala stirred up quite a controversy this Saturday when it decided to amend the Police Act and bring in what many are calling fairly draconian measures to deal with abusive content online. In this episode of Government Matters, Apurva Mandhani, who tracks law for ThePrint, will try and decode these amendments and also tell us what it means in terms of precedents, in terms of repercussions, in terms of the powers this gives police, and also importantly, what does it mean in the context of the Chief Minister's statement today where he said they will not be implemented immediately and that he will have a debate in the State Assembly first. So do start sending in your questions in this episode of Government Matters right away. Apurva, let's first talk about the amendments. You know, it was all over social media and news space over the weekend. It is, of course, something which has been criticized by his own party because these are the kind of allegations they make against the BJP of trying to stifle free speech. But just run us through these amendments and explain what they really mean, because we want to cut out the noise that has been happening over the last 2 days.
Sure, Ruhi. So essentially the ordinance now brings in a new section within the Kerala Police Act, the section 118A. Just to break it down for our audience,
sure.
It can be divided into 3 parts. Essentially, it criminalizes any information or communication or publication that may be threatening, abusive, humiliating or defamatory. Okay, this is the first part. Then the person who's making such a communication on any mode of communication, basically on any platform, which will include social media then at the end of the day, should have known it to be false. That's another thing. And the third point is that such a communication should cause injury to the mind, body or property of any person. So if these 3 things are satisfied, basically it prescribes a punishment of 3 years imprisonment, a maximum, and along with a fine of 10,000 rupees. So this is the law that has been brought in now.
Right. Now, so explain to us what this means in the larger context, in terms of what does the law say otherwise in other states? Is this the most stringent for such an offence?
Of course, so Ruhi, actually, the IT Act had a similar provision, Section 66A, and that's what everybody's talking about now. And it was struck down back in 2015 in Shreya Singhal case. Now, if I could talk a little bit about that, because that's the closest parallel that people are drawing to this new provision. Essentially, Section 66A also, it banned what it said were offensive messages. Offensive or menacing, it used words like when the messages cause annoyance or inconvenience to people. Now, this provision was very similar, as we can see, to what we have now. But it was struck down by the Supreme Court back in 2015 on 2 major grounds. Firstly, now as we know that Article 19(1)(a) provides guarantees of freedom of speech and expression. Article 19(2) then has certain reasonable restrictions. So not like it's absolute, so to say.
Correct.
We do have 8 restrictions, which includes morality, public decency, defamation, incitement to an offence, contempt of court, security of the state. So we have these already laid out restrictions. What the court said back then was that the sort of restrictions that Section 66A places do not fall in any of these 8 restrictions, and these are the only ways in which speech can be curbed. That was one.
Right.
Secondly, and that was a larger issue, that these words that have been used in Section 66A, the court said these were very vague. And that the court actually said that this would encompass any sort of opinion that anybody puts out, because any opinion can be offensive to some other person. Correct. Right? Anything that I put
it's
out.
Subjective,
so,
right.
Exactly, it's subjective. So that was the biggest pointer and challenge, because then when such a thing happens, when a provision is vague, it is prone to more abuse, so to say.
Right. So what kind of repercussions do legal experts see it having in terms of the kind of powers it gives to the police and in terms of what it enables the government to do? Because the big concern is about how the government can perhaps misuse provisions like these.
Of course. So like I mentioned, that the biggest criticism of Section 66A was, and a similar parallel criticism has come for Section 118A of the Kerala Police Act, that the provisions are, the words used are broad. When the words used are broad, neither the person knows what sort of offense they're committing, because people need to be sure about what they're posting, whether it can land them in jail, right? And secondly, of course, that there's a procedural aspect to this too, that Section 118A is a cognizable offense. which basically means that the police can, if they get to know of an offence being committed, they can register a case suo moto on their own, and they can also arrest without a warrant. Now this becomes a concern because then it does give wide-ranging powers to the police machinery to act on any sort of, like I mentioned, anything that's threatening or abusive, or words like humiliating. How do you define this? It's not defined in the sex provision as well. So it becomes very subjective like that, plus it being a cognizable offence, like I said. There's another pointer also, and this has actually been, this was pointed out in the Supreme Court judgment too, that now, for example, section 118A mentions defamatory content too. Defamation is criminalized under IPC. Correct. As we know it. There's also procedural safeguards on this thing which are present in CRPC, which say that only the person aggrieved should be able to file a complaint of defamation. So when a new provision like this is added, what happens to these safeguards? Are they there or not there? So those things are the ones that are leading to criticism.
Fuzzy areas.
Exactly.
Right. So Purva, now today, as I was mentioning, Comrade Vijayan has also said that he's not going to get these implemented immediately, and that there would be a debate in the State Assembly. Now, obviously, there is a bit of the government being on the back foot because of the kind of backlash that has been seen, including, as I said, within his own party. But where does it stand as of now? What does he mean when it says it will not be implemented right away?
So honestly, that is the law of the land as of today, because no official order has been issued staying the ordinance, and the ordinance says that this ordinance will come into effect at once, basically meaning that the moment it was promulgated, it became the law, and just a statement won't change that. There needs to be official action staying it.
Right. All right. Okay, so let's start taking these questions.
Sure.
The first question is from Eshtiva Prakash. This is seen as a reactionary measure to counter the hate comments and hordes of transphobic comments by the IT cell. Should this law not be seen as an unisolated event? So I think, just to sort of make this question a little wider, I think the point is about, whether it's being seen more as a political issue than as a legal issue, as far as the legal fraternity, as far as experts are concerned, because on the one hand there is the BJP ecosystem, which allegedly has hateful content that pushes out on social media, and on the other hand a left party government is coming up with a harsh law like this.
Of course, Ruhi, actually there is a recent editorial that was written by a senior advocate for one of the publications, where he spoke about how this law might actually prevent fake news, and this is how we should see it. Majorly because of the fact, like I mentioned the 3 ingredients, right? Majorly because of the fact that he seemed to say that truth will then be a defense to anything, right? But then again, there are procedural issues that come up. Like I mentioned, the fact that it's a cognizable offense, which is a huge thing, right? About giving wide-ranging powers. So again, in political
fact,
or not.
If I may interrupt,
sure.
You must log on to our Instagram handle today to watch our daily property Today I Learned, where we talk about what a cognizable offense is in just one very quick Insta minute. Sorry, Apurva. Sorry to interrupt.
Okay. Yeah, exactly. So you should go watch it, but that's what it makes it a cognizable offense. So while some people are in fact viewing it as a weapon against fake news, there are still procedural irregularities that even these people are highlighting.
Right. Okay. Prakhyat Sharma, how can we frame a law that protects from online abuse but does not hurt freedom of expression at the same time? So, this is a bit of a thin line, this is a bit of a fine balance to sort of take action against online abuse and yet allow freedom of speech. Where is the middle path?
The middle path, I think, taking from the Supreme Court judgment and whatever's been written so far about it, we do have the IT Act. There are certain loopholes there that we need to fasten. There's intermediary guidelines, that's another debate altogether. But this debate right now is all about, so even the Supreme Court said that whenever restriction is placed on free speech, it should be couched in the narrowest of terms. So I think that could be a starting line where even if we're trying to bring in a law restricting free speech online to, curb abusive language or abusive messages, then that should be the starting point of couching it in the narrowest of terms and not vague terms.
Right, not as broad and as
exactly
widely defined as this law does. All right, Dev Verma, isn't online abuse covered by the defamation law already?
So it is. Defamation is again another crime in itself. There's civil definition, there's criminal definition, so that is covered. But here we are, like I said, the law here, it's much wider. Like, so for example, defamation is when you say something about, harming the reputation of another person. Online, when you talk about online speech, it might not always be that. It might actually be abusive if you go to see. But it might be defamatory too. So it just depends on what sort of message we're talking about online.
Right. Okay, we've already answered this question. There's another question from Sameer Raut on political parties spreading fake news, etc. So we've, I think, already taken that earlier. Vineet Ambad, do you think this harsh law could be rolled back in the near future due to backlash? So you've mentioned, we've talked about how as of now it stands because the ordinance said it comes into effect immediately. But what is the process of then? So basically, essentially, after 6 months, you just don't pass it because it's an ordinance. Is that the process of?
Yeah, I mean, they'll have to lay it down before the state assembly, and the state assembly will have to approve it. And if it is not approved within 6 months of the 6 weeks, of the state assembly sitting, then it lapses on its own.
All right. Okay. This question by Tarush. Has the left communist parties, have they finally lost their moral right to speak about freedom of press, liberty, rights, etc.? I think I'll take this one.
Yeah.
I mean, I don't think any political party at this point can quite stand up and speak about freedom of expression or rights at this point. And the left, particularly the conventional left, the electorally active left in India, has not always really been known for allowing too much of a democratic expression, or even whether it's intra-party or whether it's outside. The kind of rule that was there in West Bengal for over 3 decades spoke for itself. The politics of violence that the culture of political violence in West Bengal and Kerala tells us that this really, that there is a thin line between the right and the left when it comes to democracy, when it comes to commitment of freedom of speech, and when it comes to commitment to allowing complete freedom of expression. Apurva, so coming back to this, very controversial law, are there similar examples in other states that we can think of?
Actually, there's an example in Kerala only that I could think of. I couldn't mention it before. In the Shreya single judgment itself, there was section 118D of the Kerala Police Act, which has been amended now. And this was a very similar provision actually, which said that any message that causes annoyance to anybody, if repeated messages are sent or repeated emails are sent, then that criminalized it. Again, the Supreme Court said that the same observations that we made for section 66A would apply in this case as well. So this was a very similar provision with Kerala. Kerala has had experience with this before. So the new law does use slightly different language. It talks about like I said, threatening or abusive or defamatory, humiliating aside. Humiliating, again, I feel is a very vague term, but all of those aside, it has tried to bring in different terminology when it has tried to sort of criminalize the same thing that it did by the previous provision. But now it has gone to the court, so we'll have to see what the court says about this.
Right. So, Apurva, just to understand that, if the government does decide to go ahead with it, although right now it just seems a little bit shaky, then what can the matter be taken to the Supreme Court? Can it sort of be struck down by the Supreme Court?
Absolutely, that's always a possibility. And in fact, 2 petitions, at least 2 of them, have already gone to the Kerala High Court, and they'll be heard very soon. We have one filed by UDF, one filed by the BJP, and the Kerala High Court will be taking it up. They've gone to the High Court, meaning whatever judgment comes out, it is expected that a challenge will go to the Supreme Court as well. So that's always a possibility.
All right. Ishna Agarwal, do you think there's a possibility of the government reintroducing a law as stringent as 66A since the crackdown on online dissent has only grown?
See, like I said, even with the growth of online dissent or online abusive messages, even if they decide to introduce a similar law, they will have to use a very different terminology, and they'll have to couch it in narrower terms. They'll have to make sure that all the safeguards and all the concerns that the Supreme Court raised in a 2015 judgment are taken care of at the end of the day, because if the Supreme Court has struck down a similar law once, nothing stops it from doing it again.
Right. So Apurva, I know I mentioned that we should watch Today I Learned, but just to give us a sense of how stringent this is, just explain what a cognizable offence entails.
Of course. Basically, a cognizable offence is one where the police can arrest without a warrant. Otherwise, you need a proper, arrest warrant to do that. In cognizable offences, also the police, if it comes to know of any such offence being committed, and they're usually more serious offences like murder, you say rape, or you say theft, they're usually more serious offences that are cognizable. So if the police comes to know on its own of such an offence being committed, it can actually register a case itself too, so moto. So these are wide powers to the Supreme Court, right? Even for investigation to the police, sorry. So even when it comes to investigation, it doesn't have to wait for an order from the magistrate. It can start it without such an order. So this is how cognizable offences are more stringent. They're more serious in nature generally, like I mentioned with the examples. Plus they give certain wider powers to the police to act on their own, basically on their own regard, to figure out what's really happening in a case.
Right. In fact, I thank you for explaining this, because by sort of explaining what cognizable offence entails, I wanted to give a sense of how stringent the new amendments to the Kerala Police Act are. Well, thank you for watching Government Matters and for sending in your questions. Keep subscribing to our YouTube channel, like our Facebook page, and do follow us on Twitter.